because they did not conduct this investigation, they really don't know what actually happened.
I'm going to sustain that objection.
Your Honor, the witness didn't recover the data sheet either. All materials during the investigation were given to the witness.
Just to be clear, are we still objecting?
Your Honor,
Yeah.
respectfully, you sustain the objection.
Can you provide a little bit more context as to why you're submitting?
The objection raised is not an objection. No rule was cited, and in Midland's law, that is not a valid objection to a piece of evidence being admitted.
Your Honor, may I respond? The objection, sorry, if you want.
Yes.
The objection I raised is hearsay objection, as this specific document does not pertain from what they've seen. This has simply just been given to them. They do not know what the truth of this context is. That's why simply we're respecting for it not to be entered into the court today.
If I may respond, if this is a hearsay objection, Charlie Martin is a party opponent to Taryn Rivera under 801(2)(d)(a). This document can be used as an opposing party statement.
Your Honor, may I respond?
Give me just 1 minute. Sorry. Yeah. Um,
801(d)(2)(a).
let the prosecution clarify what you're intending to use this piece of evidence to be submitted.
We're using this to reveal statements given by the defendant during a police interrogation.
Your Honor, may I respond?
Yes.
Specifically, if they're using this for that, they again cannot state anything because this would be hearsay and they're speculating. This is not an report that they've conducted. This is not an investigation they've conducted. They simply just got in this report. Respectfully, we ask this witness not to speak anything on behalf of this report because it will be hearsay.
If I may direct your attention to pre-trial motion C. The admissibility of interrogations is allowed. They may be read onto the record by counsel for either party or through a witness without additional foundation, and at any point once the record is open. Counsel may object to other evidentiary grounds, but as Rule 801(d)(2)(a) states that opposing party statements are allowed, this objection is not valid.
All right. I'm going to retract my previous statement and
Your Honor, sorry, additionally, opposing counsel has failed to mention a cruel sentence in that statement. The last sentence says, however, parties may object to particular parts of the interrogation on other evidentiary grounds. That's what we are objecting to. We do not want them reading out statements as they will be speculating on what this witness has said.
Your Honor, may I respond? This is not speculation. This is in the document. This is not hearsay. It is an opposing party statement. All matters have been satisfied to submit this document into evidence.
I would like this document be submitted into evidence if you would like to raise objection with like any given statement, given what you just mentioned. Let's.
I'd like to direct your attention to line 107. What does the defendant admit to in that line?
Objection, Your Honor. Speculation, hearsay, we do not want these statements being set up. That's why we objected to it as it's been entered. We do not want the witness stating specific sentences of that.
Your Honor, if you direct your attention to Exhibit 7, and I believe, I'm sorry, may I approach the bench?
Yes, you may.
Is see that, thank you. Line 107, This is not speculation. It is stated directly in the document that is in evidence. It is not hearsay. It is an opposing party statement, as has already been said. It is allowed to be read onto the record according to pretrial motion C.
You have something that you'd like to say?
Your Honor, it says, the motion specifically says, at trial, defendant's interrogation or case interrogation may be read onto the record by counsel for either party or through a witness without additional foundation at any part of the part. So, Your Honor, again, this should be read out by the counsel, not by the witness.
My apologies. I'll read it out.
Let's do that.
In line 107, Martin says, yes, of course. I admit I put it in the mask.
Yes, referring to oxalic acid.
Objection, Your Honor. This witness is speculating. That sentence specifically said, yes, I put it in the mask. They do not know what this thing was put in the mask.
I'm sorry. Let me read further. Officer, the bottle says oxalic acid. Later on, the officer says,
Sorry, Your Honor, was objection sustained?
Yeah, yeah. Sorry.
in line 88, the officer is referring to a bottle labeled oxalic acid. The officer later says, the same acid you used to clean your floors was found in Armstrong's bloodstream. Martin says, I wasn't trying to hurt anyone. I did not think it would be enough to show up in a screen. The officer asks about Martin's intentions, and Martin says,
Objection, Your Honor. The statements the officer has made is hearsay. That is not excluded from hearsay exceptions or under non-hearsay 801.
May I be heard?
Yes.
These statements are being used for the effect on the listener. They are not hearsay. They are providing context for the defendant's responses.
Your Honor, may I respond?
Yes.
Again, what they are referring to, what the officer said, is hearsay. They could simply refer to Charlie Martin's statements. They cannot refer to what the officer has been saying.
Your Honor, hearsay is a statement being used for the truth of the matter. These statements by the officer are not being used for the truth of the matter.
Your Honor, may I respond? Respectfully, if the statement says that there was oxalic acid, that is putting a question in the jury's mind that cannot be held to the truth of its content.
Can I have you reread the exact statement that we're...
Referring to oxalic acid, the officer asks, you want us to believe you put it there not intending him to breathe it in. It is a question. It is not stating any sort of facts.
Your Honor, may I respond? The first part of the sentence simply says oxalic acid. The question comes afterwards. They cannot say what the officer is saying, as that is hearsay.
Given the context of the previous sentence, I'm going to overrule your welcome to the grace.
And then, in response to the officer's question, yes, of course, I admit I put it in the mask. This is referring to oxalic acid. Reflect on shooting exhibits.
Objection, Your Honor. Was there a question to that? They just read out a statement.
Yes, according to pretrial ruling C, which you have read, the counsel is allowed to read statements from exhibits, including interrogations, onto the record, which is what I have just done.
Of course, Your Honor, but the counsel is narrating now. There was no question asked to the witness. That is them narrating what's been said in the statement. They could simply say this in their opening or closing. They cannot say this during a direct examination where there was no question asked afterwards.
Your Honor, if I may respond? Yes. According to pretrial ruling C, counsel is allowed to read things onto the record during examinations. At any point during the trial, they may read it onto the record.
Okay.
Your Honor, again, this, in a direct examination, first of all, this could be leading. Second of all, if there's no question asked, you could simply go in a cross-examination or a direct examination, read the statement out loud. What's the point of the witness being there?
I'm going to sustain that objection.
Thank you.
Could you read line 107 onto the record, please?
Objection, Your Honor. They cannot read the sentence above. It has to be read out by counsel. I'm simply just asking them to ask a question if they have a question on that simple sentence.
Okay.
So
the same scene?
No, okay. Line 107 says, yes, I admit I put it in the mask. Did I read that correctly?
Yes, you did.
Objection, Your Honor, leaving.
Your Honor, I'm asking a clarifying question. The witness is free to answer any way they please. It is not a leading question. They can answer any way they want. I'm not directing them to an answer.
Your Honor, if they've just said, and I'm reading that out properly, correct, they're leading the witness, they haven't said or seen the specific thing.
I'm gonna sustain, can you just rephrase?
Referring to line 107, does Martin say anything?
Martin says, yes, of course, I admit putting in the mask. Referring to oxalic acid.
In your investigation
Objection,
during...
Your Honor, we want the last statement stricken out of the record as they're speculating.
Your Honor, during pretrial